This is case number 2698FY, appearances counsel.
Hey, Carnes, on behalf of the people.
And I'm Jeff here, so I'm here on behalf of Kristen Schwartz. She's next to me at the table.
And we are here for a probable cause conference. Is there any resolution to this matter?
Yes, Your Honor, it's my understanding that the defendant will plead guilty to an added count of attempted RNO as well as count 2 disorderly person. The people will dismiss the completed offense, count 1 RNO, as well as the habitual offender 4th enhancement.
That's my understanding as well, Your Honor.
Counsel also, so you're aware, I have an amended complaint in the file from January 12th. That's just correcting the spelling of Ms. Schwartz's first name. I don't see a need to rearrange her on that, but Ms. Schwartz, have you heard what the attorneys have said the resolution in this case is?
Yes, Your Honor.
And is that how you wish to resolve it?
Yes, Your Honor.
So it's my understanding that you'll be pleading guilty to what is essentially an added count 3 of an attempt to resist and obstruct a police officer. That is a misdemeanor punishable by up to 1 year in jail and or a fine of $1,000. Additionally, you'll be pleading guilty to count number 2 of disorderly drunk. That is a 90-day misdemeanor and or a fine of $500. The people in exchange for those pleas will be dismissing the completed offense of police officer resist and obstruct, the 2-year felony, and the habitual 4th offender notice. Do you understand that?
Yes, Your Honor.
And is that your understanding of the plea agreement?
Yes, Your Honor.
Can you please raise your right hand as best as you can? Do you solemnly swear or affirm this testimony you've given this matter will be the truth, whole truth, and nothing but the truth?
Yes, Your Honor.
Do you remember reading and signing an advice of rights form in this case? It talked about your rights to a trial and your rights to an attorney.
Yes, Your Honor.
Did you understand those rights?
Yes, sir.
Most importantly, do you understand that you have a right to a jury trial and that by entering a guilty plea today, you'll be giving up that right? You won't have a trial of any kind.
Yes, sir.
Back on January 8th of this year, were you on probation or parole?
No, sir.
Were you on bond?
No, sir.
Other than the plea agreement, has anybody promised you anything in order to get you to plea?
No, sir.
Has anybody threatened you in any way?
No, sir.
And is it your own free choice to plead today?
Yes, sir.
Are counsel aware of any other promises, threats, inducements not made part of the record?
No, Your Honor.
Nor am I.
The Ms. Schwartz, to the allegations that on or about January 8th, 2026 in the city of Cadillac in Wexford County, how do you plead to count number 2 of disorderly drunk
Guilty.
and to added count 3 of an attempt to resist and obstruct a police officer? How do you plead?
Yes.
In order to accept those pleas, I must have you tell me what it is that makes you guilty. So what happened back on January 8th?
I was dealing with a lot going on lately. People always says I've been asking, reaching out for help. It didn't go in my favor, so I went out and started drinking and being irresponsible. I take full account of my actions, and I'm truly, truly sorry. And I was in the wrong. I went down the road and don't remember half of it, but I remember being in the cop car and what happened, and
So what happened in the cop car?
I slipped my cuff and waved at the camera.
Slipped your cuffs and what? Waved at the camera?
Waved at the camera.
Okay.
And I was very drunk and irresponsible on it, and I'm sorry. I am seeking, reached out for rehab. I have been approved. That's why today I was wondering if I can, be on a PR or something, so I can go straight to rehab.
We'll get to that in a minute. Right now, I have to have you finish telling me what happened. So how were you a disorderly drunk?
I drank a fifth, almost a fifth that time.
Okay, and what happened?
Walking down the road, I guess I went to the bar and I didn't have no money and I caused a scene. Very irresponsible there.
Well, this says at the Chris gas station. So did something happen at Chris?
I left the bar and I walked across the street and I made a scene in the parking lot.
How did you make a scene?
I got a mouth on me sometimes when I'm intoxicated. And yeah, I'm truly sorry.
What does and yeah mean? I need you to tell me what you did.
I think I was yelling at people in the, right where the pumps are.
You think or you know?
I know I was.
Okay. And then is there more to the resist and obstruct other than just slipping your cuffs?
No, sir.
Counsel believe defendants provided the fact, and that happened here in the city of Cadillac?
Yes, sir.
You counsel believe the defendants provided a factual basis in which to accept the pleas and the court rule has been complied with?
Yes, Your Honor.
I do as well.
As does the court, I find the plea is knowing, voluntary, and accurate. Ms. Schwartz, I find you guilty of an attempt to resist and obstruct and disorderly drunk pursuant to the plea agreement. The completed offense and the habitual fourth offender notice will be dismissed. Mr. Carnes, are we able to sentence today?
Yes, Your Honor.
Mr. Harrison, any allocution?
Indeed, Your Honors, Crystal mentioned to you in her presentation to the court, she has sought rehabilitation, inpatient treatment. She has in fact been approved for that. I do have a letter to that effect in her file. At 1016 Recovery Network, that is her eyes on the prize. That is her next objective, irregardless of what happens today. Not that the court sentence isn't important. I'm saying that's where she's going next, whether you put her back in jail or you release her today. I think even a brief look at her criminal history would indicate that this is a step she probably should have made 10, 12 years ago. And nevertheless, I'm proud of the fact that she sought this on her own, not through anyone forcing her to or in consideration of anything else. Many times a case like this goes by without there being any intervention as to the underlying behavior. So I'm glad that she has the insight to at least realize this is a major problem. This could have sent her back to prison because she decided to drink and act irresponsibly here. That's a big realization for her, and I'm glad she made it. Those are her words, not mine. She does have some jail credit, and I think she spent that time appropriately considering how she can avoid putting herself right back in the same position that she's been in on numerous prior occasions. I think a period of supervision would be beneficial to her as well. In effect, it would be another reinforcement of whatever aftercare she receives through 1016. Obviously the court has ample discretion here. I just wanted you to know that our emphasis is definitely on getting her, or her emphasis is getting herself into treatment.
Thank you. Mr. Carnes?
Thank you, Your Honor. Looking back at the defendant's criminal history, it does appear this is an annual issue, roughly, with R&O in 2013, probation revoked. A completed R&O in 2015 with a PV, which ended in a prison sentence. A assault and battery in 2017. I note there disorderly person drunk. Attempted R&O in 2017. Completed R&O in 2018. Domestic violence in 2019. Another R&O also in 2019 with a disorderly person drunk dismissed. Disturbing peace in 2024. Disorderly person drunk in September of 2025, and now I have this behavior. And I completely think the defendant gave pleads to the best that she remembered it. However, the Cadillac police officers report that in the Sally port, she jumped out of the car and had she slipped out her cuffs, and she had one handcuff in the other hand and was threatening the officer with his own set of handcuffs, essentially. So it does appear to be a bit more aggressive than what the defendant recalls. Also, the attendant at the Christ gas station said she got close to her and said, "I want to tell you something," and then she yelled something vulgar in her face. So it's an ongoing issue, and the defendant is disturbing the peace of multiple people, both at the party lounge and the gas station. And then the arrest goes rather difficultly. I'd ask the court for 180 days jail. Thank you.
Mr. Carnes, when you say she was threatening the officer with his handcuffs, what do you mean by that?
I mean, she said, "Let's go, bitch," in the saddle court, according to the officer's report. Had the handcuff in one hand. And nobody was hurt. They were able to see her and book her without further incident.
Did she slip both wrists or just one?
Just one.
All right, so one was still around her.
I think so. That's my best guess based on.
Ms. Schwartz, you have the right to address the court prior to sentencing. Is there anything you'd like me to know?
Sorry for my actions. I'm reaching out for help. I have connected in the jail, on my own for rehab. I have been approved. I have reached out for CMA, which I am at, in jail. I have been seeing. I have been reaching out to Catholic Human Services for help. I am truly sorry for everything I ever done. And that was, I tried so hard to fix what I broke. I've been going through a lot, and it's my fault. But I have been intervening with Oasis, and they've been turning me down. Even when I was sober, I counteracted and I went back to the alcohol. That was my bad. I understand. But right now, I am trying so hard to fix that day. It's not like I was drinking every day. I'm not. And I'm truly sorry. Please work with me. I'm trying to get out. And I talked to 1016 today as well. I call them every day. And I told them I had court, and I'm trying to see if I can get out today so I can be in the facility within this week. They have me coming, you know what I mean? Nobody asked me to do this. I'm doing it because I am scared. I can't fall back on what I did in the past. I can't, but I gotta take actions for what I'm doing now. And I have been reaching out for help. I have been paying on my fines. I've been looking for work. And maybe in a jail, I lost that job, but that's okay. I can find another one. But I'm asking, please work with me. I'm asking to let me out so I can go to rehab this week. I have to go to the doctor for my bipolar schizophrenic, and that don't help my case either, you know? But I'm not out doing, I'm not getting in any kind of other trouble. I did that day, and I'm so sorry. And like I said, I could be in rehab. If I get out today, I could be in this week. And I am trying. I am really, really trying. I will even do probation. I will come and do breathalyzers like I did before. Anything. I am reaching out for help and guidance and strength to keep going. I know I messed up. And I'm not perfect, and I'm not going to ask you to sympathize with me, but I'm telling you, I'm sorry I got in everything, and I'm trying to keep reaching out. I asked 1016 for resources once I'm out as well. You know what I mean? Like, counseling, all of it, just trying to save my marriage. I'm trying to do the right. That's all I can say, Your Honor. Thank you for your time and thank you for listening. I'm sorry.
So back when you were sentenced for disorderly drunk in September, what did you do after that?
September. I was in and out of trying to get into Oasis. And the counseling there and stuff like that. Me and the staff member at Oasis did not like me and did not want me there, so I couldn't be, you know. But, I reached out to Catholic Human Services and trying to get back into counseling and going through the trials of those, EBT classes or whatever you call them, Catholic Human Services and stuff like that, so, I wasn't drinking, I was looking for work. I got a payment plan to pay on my fines once a month.
So you say you weren't drinking this and one day the world fell apart on you? I mean, do you expect me to believe that you haven't been drinking between,
No,
Okay.
I'm not saying that.
so
but I mean-
then why do you tell me that you weren't drinking?
But I drank like once before that, but I've been trying to do the right thing by looking for work, getting back and looking. And then I backslid that one time. And I don't know. And I just finally got back on my meds. I wasn't on my meds at that one time. And I finally got my doctor, and me and her even talked about rehab. And I have been working on a plan. That's why I'm working so hard, trying to get out and ask for help. Like I said, I'll do probation, I'll do the breathalyzer. I'm in counseling and anything and everything. I will come here straight after jail if I have to and sign up for probation pay. I'm trying to do marriage counseling to save my marriage. I love my husband. And I'm so scared of losing him due to my actions.
Anything else?
Nobody promised me nothing. I'm doing this all on my own. I don't. I'm going back and I won't ever make it back out. And I don't want that if I'm so hard for help. And I'm asking you and the court to help me to get through. Because if I don't ask for help, there's no other way. Thank you, I'm sorry.
All right. When I go through Ms. Schwartz's history, I find in 04, there was a domestic, 04 a use, 07 an operating while intoxicated, 08 a domestic, 08 an operating while intoxicated, 09 a domestic second, and 10 a retail fraud third, 12 driving while license suspended, and 13 an attempt to resist and obstruct an officer, 15 a resist and obstruct, and 16 tamper with electronic monitoring device as an attempt, and 17 an assault and battery, 17 an attempt to resist and obstruct, 18 a resist and obstruct, 19 a domestic, 19 resist and obstruct, 24 domestic and disturbing the peace, and 25 a disorderly drunk. By my count, that's 5 prior resist and obstructs. Also 2 prior disorderlies. Mr. Carnes mentioned that some of those had also had the disorderlies dismissed as part of the plea agreement. I had staff pull the last 2 cases, and it looks like the 24 domestic and disturbing the peace, my predecessor had ordered 93 days jail suspended with 6 months of probation. And then when we were here for the last disorderly drunk, looks like I just did fines and costs and time served. Mr. Carnes also referenced different probation violations and terminations that the defendant has. Going through her history, one of the things that the court has to be convinced of is that probation is beneficial and will not the likelihood of reoffending is slim, and I just don't see that here. Ms. Schwartz has a history of assaultive behavior in her past. She has a history of resisting and obstructing in her past, and she has a history of disturbing disorderly behavior. As such, I do not find her as a good candidate for probation. She currently has 12 days I believe it was 12 days jail credit so far on this case. It's also alleged in this case, or she's pled to an attempt to resist and obstruct, in which she slipped her cuffs off. She was in the sally port threatening law enforcement to fight with them. This is not somebody who is just simply saying, no, I'm not going to do something. This is somebody who has a history of resisting and obstructing. She threatened law enforcement. She slipped her cuffs. She created a very dangerous situation for law enforcement and those in the sally port, and potentially those in the jail itself. So I do find that jail sentence is appropriate in this case. There will be a $75 crime victims' rights fund fee, two $50 state minimum fees, $150 fine, $150 court costs, $150 attorney fees. She's entitled to 60 days, I'm sorry, $60 credit back towards those fines. Sentence today will be 300 days jail with 12 days credit. Ms. Schwartz, because I have sentenced you to a period of incarceration, and you decide that you want to appeal that decision and could not afford an attorney to assist you, you have 14 days from today's date to request the appointment of an attorney. Also, any balance that remains unpaid for more than 56 days will have a 20% penalty added to that. I will waive that while you are incarcerated.
Will the court consider an early release to treatment?
I won't today, but you can certainly bring that up at a different time if you desire.
Thank you.
All right.
I'm sorry, Your Honor, if you're speaking, I see you're muted.
Sorry, I apologize. I just asked if there was any resolution to the case.
All right,
Mr. Harrison indicated there was not as of yet. Obviously, he's not able to post a 25% bond. So that brings me to my next question. Mr. Harrison, are you planning on a prelim next week on this?
I don't see that there would be any, frankly, any reason to conduct a prelim. I'd like to keep the date in the air just so there's some incentive for us to resolve whatever we can resolve.
All right.
We discussed it with Mr. Mayor. We don't believe there's any logical reason to hold a prelim.
Sure. Do you have the discovery you need right now, do you think?
I do not. But that could be just a matter of it being processed.
All right.
The public defender's office has been in contact with them.
who should we send the discovery to? I'm sorry, Mr. Harrison. What's your first name?
It's Jeff Harrison. I'm the public defender on the file. I didn't know that another appearance was even contemplated.
All right.
I'm not sure there was. I think there's
Okay,
just some
okay.
confusion as
All
to
right.
who had what case, so.
Then I share in your confusion and
So Ms. Getz is not on this case. All right.
okay.
We
All right.
will get, Mr. Harrison, we will get you the discovery packet. I'll have it emailed to you this afternoon. I assume all your contact information is in the Bar Journal.
Correct.
All right. And
All right, then we will.
we'll plan not to bring any witnesses then to the prelim, which
I think that's correct at
All right.
this juncture. We'll discuss it in between.
okay. And you know the standard offer in these cases, correct? All right.
Yeah.
All right, then we will keep the matter set for prelim next week and we'll see where we wind up. Anything else for the record, counsel?
Sounds good, Your Honor. Thank you very much.
All right, thank you.
We'll work backwards from that. Okay. All right.
Court next calls the people of the state of Michigan versus Laura Marie Webster, case number 26-101FY.
I'm Jeff Harrison on behalf of Ms. Webster.
I
She's
just
joined
had
me at the
Maria
table.
check it. She was like.
Counsel, we are here for a probable cause conference. Is there any resolution in this matter?
There is none, Your Honor.
So that means, and we don't have a waiver of the 21 days, is that correct? So that means we are set for a prelim next week. Mr. Harrison, do you have everything that you believe you need for that?
I believe so. Your
Ms. Dahl, are you aware of any issues that might pop up between now and then?
Honor. Yeah, okay, for a prelim. Okay.
I don't have any information. Any delay.
All right. Then we will keep this on track for a prelim for next week. Anything else for the record, council?
Nothing at this time.
No, you're on.
All right, thank you. Ms. Webster, just a reminder that your bond conditions continue. All right. You can go out to the front window where you checked in and get your next court date. Thank you. Court next calls the people of the state of Michigan versus Laura Ann Squire. This is case number 26-147 FD, appearances counsel.
And I'm Jeff Harrison. I'm here on behalf of Ms. Squire. She's joined me at the table.
And we are here for a probable cause conference. Is there any resolution?
There is no resolution, Your Honor. We did indicate that we waived the 21 days in this case because there was a blood draw.
Okay.
And I just don't, I don't want to get here next Tuesday and have there still be no blood draw and have to adjourn. So
All right. And counsel, you haven't received the blood draw on this one yet?
No, I'm not. You're on.
All right. Okay, yeah, this just happened last week, so. all
and we're
right.
working diligently to resolve it as well.
Mr. Harrison, then I'll defer to you. Are you asking to have this set to the 27th, or do you want to go another week out?
I think to be safe, we should go another week out.
Any objection to that, Ms. Dahl?
No, Your Honor.
That'd be February, what, third?
February
Third.
3rd.
Third,
Yeah.
okay.
All right. Then we will set this out to February 3rd. Anything else for the record?
No, Your Honor.
Nothing from us, Your Honor. Thank you.
All right, Ms. Squire, just a reminder, your bond conditions continue, and you can go out to the front window where you checked in and get your next court date.
Thank you.
All right, thank you. Next is the people of the state of Michigan versus Kevin Michael Bratachowski. All right, this is case number 26-129FY. Mr. Bratachowski, or I'm sorry, Bartachowski, you had indicated at your arraignment you were going to hire an attorney, but we don't have an appearance yet. All right, do you, I'm sorry, I can't hear you. All right. The court will then make a referral to the public defender's office for the appointment of an attorney. We'll continue the not guilty plea and we'll reset this matter for a probable cause conference. Any objection to that, Mr. Carnes?
No, Your Honor.
All right. Sir, you can go out to the front window where you checked in, get your next court date. You'll have some paperwork to fill out for the defender's office. And just a reminder that your bond conditions continue. Okay, thank you. Next is the people of the state of Michigan versus Douglas Messiah Finney. This is case number 26130FY, appearances counsel, starting with the prosecutor.
Nate Carnes on behalf of the people.
Good morning, Your Honor. Allison Castles and Attorney Lynn Getz on behalf of Mr. Finney.
And we are here for a probable cause conference. Is there any resolution in this case?
There's not, Your Honor. We've still not received body cam discovery. I spoke to Mr. Carnes, who advised he's also not received that. So we'd be asking to set the preliminary exam out about 3 weeks.
Mr. Carnes, how long do you think it's going to take to get body cam? That's usually a pretty quick turnaround, isn't
It
it?
usually is, Your Honor, but we're dealing with the fugitive team. We did send out an email on Friday and that got forwarded on to somebody else at MSP that we've never dealt with before. I would hope we'd have it in the next day or two. I do think a 3-week adjournment is appropriate given the nature of the case. Defendant's out on bond, and there could be a fair amount of body camera for us to review before we can resolve it.
All right, given the stipulation, then we will set this matter for preliminary examination and we'll go out February 10th. Is there anything else other than body cam we're waiting for?
No, Your Honor.
Anything else for the record?
No, Your Honor.
No, Your Honor.
Mr. Finney, just a reminder that your bond conditions continue and you can go out to the front window where you checked in and get your next court date.
All right.
All right, thank you. Court calls the people of the state of Michigan versus Shane Michael Oxford. This is case number 26-116FY. Appearances counsel.
Lisa Bell for the people.
Robert Hartel from Mr. Oxford. I am filling in for Ms. Fiobento, Your Honor.
And where's Ms. Fiorvento?
She's in Misaki County on other cases, Your Honor.
She's in trial over there today.
No, I should have phrased that better, but there's arraignments over there. She was on the Misaki arraignments.
Mr. Oxford, you do have the right to have your appointed counsel present. Are you okay with the substitution today? Is there any resolution in this matter?
There is not, Your Honor, but we would waive the 21 days.
So that will put us out to the third. I'm sorry, Ms. Dahl, this is your case?
Yes, it is, Your Honor. I'm fine with that.
All right. Are there any discovery issues we need to be concerned about?
I believe there needs to be some clarification on how the drugs that were delivered were identified. I
Okay.
know there's Kunar, so I'm waiting to hear back from the officer in charge on the identification of the substance.
All right, so I'll just make note of that. And if something happens that we need to adjust the prelim date, we can do that by stipulation.
Thank you, Your Honor.
Anything else for the record?
No, Your Honor, thank you.
Mr. Oxford, just a reminder that your bond conditions continue and you can get your next court date at the front window.
Thank you.
All right, thank you.
Just keep that in our call.
People of the state of Michigan versus William Arthur Jordan Callahan. This is case number 25-2894FT. Appearance of counsel.
Lisa Bell for the people.
Robert Hartel from Mr. Callahan and joints with the table.
We are set for probable cause conference. Is there any resolution to this matter?
There is not. We would waive the 21 days on this one as well, Your Honor.
All right. Ms. Dahl, are you aware of any discovery issues?
Yes, Your Honor, I believe this case was already continued 1 week because we are waiting to hear back from an officer regarding another witness that I would need for the preliminary exam. I have not heard back from the officer. I know the officer replied that he's working on it. So I've not heard back yet.
All right. And it looks like we were originally scheduled for the 13th. We did that adjournment back on the 12th. So if we go out to the 3rd, do you think that that would be sufficient time?
Your Honor, I hope so. I did also get some information in custody. So I need to writ that as well to testify.
Is it DOC custody or?
I
County.
believe it's in the Waco jail, but I'm not sure.
Okay. All right. Mr. Hartel, any objection going out to the 3rd?
No, Your Honor, no objection.
All right. So we will set this for a prelim on the 3rd. Mr. Callahan, just a reminder that your bond conditions continue and you can get your next court date at the front window. All right, thank you. This is case number 26-99-FY, appearances counsel.
Nate Carnes on behalf of the people.
Robert Hartel for Ms. Emard, who joins with the table. This is another one where I am filling in for Ms. Fiobento, who's on arraignments in Misaki County.
All right. Ms. Emard, you're aware that Ms. Fiorvento is your appointed attorney in this matter and she's not available for today's date.
Yes, sir.
Are you all right with Mr. Hartel filling in for her?
Yes, sir.
All right. Council, we're here for probable cause conference. Is there any resolution of this matter?
Yes, Your Honor, it's my understanding that the defendant will enter a guilty plea to an added count of child abuse fourth, and there is a Killebrew agreement for sentencing under HIDA in this matter.
Mr. Carnes, what is the child abuse fourth is a 1 year, right?
It is, Your
What's the financial?
Honor. If you can give me one moment, Your Honor. One year misdemeanor with up to 5 years probation. I'm sorry.
I believe it's 1,000, I believe. It's a guilty plea, you said?
Yes, Your Honor, it is with the HIDA elements.
Mr. Hartel, is that your understanding of the plea agreement?
It is, Your Honor.
Ms. Emard, will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
So it's my understanding that you'll be pleading guilty to an added count 2 of child abuse fourth degree. That is a misdemeanor punishable by up to 1 year in jail or probation for up to 5 years. Additionally, I believe there's $1,000 fine that goes along with that.
Okay.
In exchange for that, the people will be dismissing count number 1 of third degree child abuse. That is a felony punishable by up to 2 years in prison or probation for up to 5 years. Additionally, there is what is called a Killebrew agreement. That's an agreement you have with the prosecutor that says you would be sentenced under what's known as the Holmes Youthful Trainee Act. And if you're successful with that period of probation, the charge would be removed from your public record. If you're not successful with it, however, though, the charge would enter. Do you understand that?
Yes, I do.
Now, do you also understand that that's an agreement you have with the prosecutor, not an agreement you have with me? So if I decide that I'm not going to follow that agreement, you would be able to withdraw your plea. Do you understand that?
Yes, sir.
Back on May 19th of last year, were you on probation or parole?
No, sir.
Were you on bond?
No, sir.
Do you understand that you have the right to have a jury trial, have witnesses called for your defense at trial, to cross-examine those witnesses called against you, the right to testify or to remain silent, the right not to have that silence used against you, to be presumed innocent unless proven guilty beyond a reasonable doubt? Do you understand though?
Yes, sir.
Most importantly, do you understand that by entering a guilty plea today, you'll be giving up that right to have a jury trial and you won't have a trial of any kind?
Yes, sir.
Other than the plea agreement, has anybody promised you anything in order to get you to plea?
No, sir.
Has anybody threatened you in any way?
No, sir.
And is it your own free choice to plea today?
Yes.
Are counsel aware of any other promises, threats, inducements not made part of the record?
No, Your Honor. No, Your Honor.
But Ms. Emard, to the allegation that on or about May 19th, 2025 in the city of Cadillac in Wexford County, how do you plead to child abuse fourth degree?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So what happened back on May 19th?
My friend had her dog over and we were uncertain how he was with kids, and I looked away for a few seconds and he got my daughter and I neglected to take her in.
Neglected
In
to
my
what?
mind, I
I'm sorry.
didn't think it was bad enough to take her in.
All right. Did she sustain injury?
Yes, she did.
And what types of injuries did she have?
It was just a small scratch to the face on her left cheek. Or no, yeah, it was the left cheek, and then her cat got her 10 minutes later in the same spot.
Was it so the cat scratched her?
It just got a little pin poke right at the top of the dog bite.
How did it get the pin poke?
I'm not exactly sure. She was downstairs with my mother.
Okay, and do you know what happened with the dog? I mean, how she was injured by the dog?
I looked away for a couple seconds and he must have like jumped up and like got her right on the cheek. I didn't exactly watch it happen. I just,
How old is your daughter?
she was 2 at the time. She's 3 now.
And how familiar were you with the animals?
I knew the puppy since the owner got it. He never showed us like signs of aggression until that day.
How familiar were you with the dog?
Very familiar with the dog.
How old would you say the dog was?
8 months,
Had your child been around the dog before?
like 2 or 3 times prior.
And had there been any issues before?
No,
And was there I think you said, but I can't remember, was there somebody with your daughter when the dog either bit her or did what it did?
it was me and my friend Michael, but she was not paying attention either.
And how far away were you from your daughter when it happened?
Maybe from me to the corner of that table.
Counsel, I can't accept the plea. Zemar, it's nothing you've done wrong. It's just based on that factual basis. I don't find that that you knowingly caused the situation or acted in a way that would have unreasonably caused the situation to happen. So, counsel, do we want to keep this on track for preliminary examination? Do we want to reset it for PCC?
Your Honor, if possible, if we can reset it for PCC next week and approve them the following week, that way I'll be gone next week, so. That February 3rd.
Any objection to that, Mr. Hartel?
No, Ms. Fiavento also informed me she'd waive the 21 days, and my client confirmed that would be acceptable as well, just so the people in the court both know that.
Correct me if I'm wrong, but Ms. Firavento's in a 5-day trial that following week, the 27th.
I'd have to double check that.
All right, we will go ahead and we will reset it for probable cause conference next week. All right, Ms. Emar, just a reminder that your bond conditions continue and you can go out to the front window where you checked in and get your next court date.
All
All right, thank you. Court next calls the people of the state of Michigan versus Crystal Schwartz. And we are here for, in the new file, looks like there'll be a plea in that case to driving while license suspended. And then in case number 24782 SD, we're here for a hearing on a sobriety court violation for the new charges in which she's anticipated plea to today. Is there any resolution in the sobriety court file?
Yes, Your Honor, she'll do an admission to that as well.
And it looks like, as I said, in the new file, it's going to be a driving license suspended. Is that accurate?
Yes, Your Honor.
And
No insurance will be dismissed.
the no insurance will be dismissed. All right. Ms. Nyman, have you heard what the attorneys have said the resolution of this case is?
Yes.
And is that how you wish to resolve it? You please raise your right hand. You solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? All right, let me put your hand down. Let's start with the new file first. That's case number 25-5088 ST. In that file, you've been charged with count number 1 of operating while your license was suspended, denied, or revoked. That is a 93-day misdemeanor. And count number 2 of operating without security or insurance. That is a misdemeanor punishable by up to 1 year. It's my understanding that the people will be dismissing count number 2 and you'll be pleading guilty to the driving the license suspended. Is that accurate? We know you were on probation at the time. Were you on bond in any other file at the time of that offense, back on the 12th of December?
No.
Did you read and sign an advice of rights form in this case? Talk about your rights to an attorney and your rights to a trial? C1. So let me go through them with you real quick.
I signed something with Rose. I'm not sure.
Okay, all right. Do you understand that you have a right to have a jury trial in this case? And at that trial, you could call witnesses for your defense. You have the right to cross-examine all witnesses called against you, the right to testify or to remain silent and not to have that silence used against you. Also, the right to be presumed innocent and to be proven guilty beyond a reasonable doubt. Do you understand those rights? Most importantly, do you understand that you do have a right to a jury trial and that by entering a guilty plea in this case, you'll be giving up that right and you won't have a trial of any kind? Other than the plea agreement, has anybody promised you anything in order to get you to plea?
No.
Has anybody threatened you in any way?
No.
And is it your own free choice to plea today?
Yes.
Are counsel aware of any other promises, threats, inducements not made part of the record?
No, Your Honor.
No, Your Honor.
Then Ms. Nyman, to the allegation that on or about December 12th, 2025, in the city of Cadillac of Wexford County, how do you plead to count number 1 of operating while your license was suspended, denied, or revoked?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on December 12th, were you operating a motor vehicle in the city of Cadillac? And at the time of operating that motor vehicle, had your license been suspended, denied, or revoked? And you knew it was suspended, denied, or revoked? And did you had law enforcement interaction that day? You did not have a restricted license, is that correct?
Are you sir?
All right. Do counsel believe that defendants provided a factual basis in which to accept the plea and that the court rules have been complied with?
Yes, Your Honor.
Yes, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. Ms. Nyman, I find you guilty of operating while your license was suspended, denied, or revoked. Pursuant to the plea agreement, the operating without security will be dismissed. That brings us to the sobriety court violation. In that allegation, Ms. Nyman's alleged that you drove while your license was suspended, denied, or revoked, and operating without insurance. Is the plan to plead guilty to both of those violations, counsel?
Your Honor, I'm willing to dismiss count 2 of the probation violation considering the plea in the new case.
All right, Mr. Hartel, I assume you have no objection to that?
I do not.
Ms. Nyman, it's my understanding that you'll be pleading guilty to basically the mirror that you just pled to before of driving while your license was suspended, denied, or revoked back on the 12th of December. Is that your understanding as to how this violation will be resolved? And just so the record is clear, this would be a 4th violation for the defendant in that on August 13th of 2024, she had a driving license suspended. March 25th of 25, she had a 2nd violation of a positive remote test and a missed test. And then on September 23rd of 25, she had her 3rd violation of a positive breath test and a missed test. Ms. Nyman, in this case, has anybody promised you anything in order to get you to plea? And is it your own free choice to plea? And has anybody threatened you in any way? Are counsel aware of any other promises, threats, or inducements in which to get the defendant to plead to the violation?
No, Your Honor.
Any objection to the court taking judicial notice of the plea that was just taken in the new file to accept a guilty plea in this case?
Not an definite offense.
I apologize, Your Honor. I was looking at something else. No, I don't object.
All right. Ms. Nyman, then to the allegation of the violation that you drove while your license was suspended, denied, or revoked on December 12th, how do you plead? The court, having heard the testimony from the defendant in the prior case regarding her operating a motor vehicle in the city of Cadillac on December 12th while her license was suspended or denied, her knowing that it was suspended, denied, or revoked, and not having a restricted license, the court does find her in violation of her sobriety court terms. So that brings us to sentencing in these cases. And I know Ms. Nyman is aware of it and Ms. Dahl is aware of it too. The sobriety court team voted as to what to do for a recommendation in this case or sanction in this case. And in their sobriety court file, the recommendation was termination. However, I still have the final say on that. So I will turn it over to Mr. Hartel. If you want to allocate in one or the other or both, I'll leave that up to you.
Thanks, Char. I believe my client will have some personal statements and moments to humanize a bit more. We did discuss what would be appropriate to say between yourself and myself earlier. I would ask the court to consider continuing sobriety court. I do realize this is totality of the circumstances. It's not just what there was a finding with now, there was prior findings as well. But I know my client's going to explain a bit more detail about why she was operating the vehicle. We don't believe it rises to a legal defense, or we really don't. But we do believe it wasn't just, so the court is aware, joyriding. It wasn't just out there looking at the colors of the trees or anything like that. There was at least what she felt was a noble purpose behind it, if nothing else. And I would hate to see all the work she's done, despite the hiccups, despite the rumble strips, despite the other issues, however we want to analogize them. She has taken pride in the fact that she has continued with the program. And I know she's taken it seriously. I can see it right here in all my prior communications. She's been very honest with me. I can normally tell when a client's trying to get one over on me. This wasn't one of those situations. She didn't deny what she did from the beginning with me. She just wanted to try to get to the best resolution possible. And I would ask the court to consider this being an opportunity for her to complete sobriety court. I do believe that would be appropriate. I do believe she would appreciate it. And I don't believe it would be a waste for her or society. I believe it would be overall beneficial. As far as the punishment on the new file, I'd ask the court to consider that being minimum fines and costs. I'll waive my attorney fee. I know it is a misdemeanor. It is still a criminal charge, but I ask the court to treat it as what it is, and she'll explain in more detail in a moment. Thank you.
Thank you. Ms. Dahl, on behalf of the people.
Your Honor, one of the things that I put in the pre-trial order is that people would not recommend jail in the new case for driving with a license suspended, and I would like to abide by that. I know there's going to be a punishment in the probation violation. With regards to the new case, we're asking that, well, we're not recommending jail in that case. And we're asking for fines and costs. I don't know if probation would be beneficial considering her probation in the sobriety court case. So I'll leave it at that. With regards to sobriety court case, Your Honor, she has been in sobriety court for quite a while. I know I just joined the team, but our discussions with the team, although I'm not going to go over them, the team, I believe almost everybody, if not everybody, recommended that she be terminated from the probation. I agree with that recommendation. I asked the court to follow that. She had violated multiple times throughout her time. It wasn't just in the beginning when she was getting used to sobriety court. It's been continuous, and the latest one being September of 2025, where she had a positive breath test, and she went to jail for that. Whatever her reasoning is for driving today is no excuse. She knew what she was doing. She knew exactly what the consequences would be if she got caught, because she's already been caught driving while license suspended while in sobriety court. This is her second time doing that while in sobriety court. I think sobriety court is a very serious program, and it's voluntary, and it's something that's supposed to help encourage people to live sober and to not commit crimes. And she has not learned that in sobriety court so far. So I would ask that she be terminated from probation in that case.
Ms. Nyman, you have the right to address the court prior to sentencing. Is there anything you'd like me to know?
When I was driving in December, I had just had surgery and something didn't go well after my surgery. And I had been in contact with my doctor and the surgery center, and they recommended that I go to the ER. or an urgent care center, and I reached out to people to help me for that. And because of prior situations where I called 911 and been hung up on twice because it's my ex-sister-in-law that works there, when I have called out for help through 911, I've been hung up on, so that is not an option for me. I was worried that I had an infection or a blood clot based on what happened after my surgery. And then when I got pulled over, I didn't go there. And then I reached out to my doctor again, and they repeatedly told me to go to the ER in the urgent care, which I did not go to until Wednesday when I had a ride.
So this happened the 12th, which was a Friday?
Yeah, and I had surgery that Monday.
And then it was the 17th before you went anywhere? So where were you stopped at?
Like when I was going through the intersection by Save-A-Lot and the coffee shop, and I pulled down. So it was over by, like the little neighborhoods back there behind like the car wash and the coffee shop right there.
Okay,
I'm not sure. What it is.
all right, I know where you're talking about. And so when you pulled off in the neighborhood, had the officer already activated his lights?
I pulled over when he activated his lights, yeah.
Okay, but when you pulled off of Mitchell's, because what I understand is you pulled off of Mitchell Street.
Yeah, he didn't activate his lights until, like if you, I think it's River Street, so like if you go all the way to where there's like a tanning salon, like strip mall
Mhm.
right there, and then I turned right, and then he turned right, and I turned left, and he activated his lights when I was turning left, and then I stopped right there
And what was your purpose for turning off of Mitchell Street?
to not get pulled over.
Was the officer, this was an MSP case, right? So was the trooper following you, or did you meet him?
He followed me, but he didn't turn his lights on until I was turning left.
How long had he been following you?
I didn't know that he was following me, and so
But at some point, you saw him and turned off of Mitchell Street,
yeah.
and then you went down to what would be Farrar Street, which is the first stop sign, took a right.
Yeah.
And went a block or two and then took a left,
Yeah.
and then that's when he lit you up.
Yeah.
And we know you didn't have insurance on the vehicle. Did you have tabs on the vehicle?
No, I think he wrote the ticket for no security, which I wasn't sure if that was, and I asked him, he said it was for the plate and the insurance.
Anything else you want me to know?
Like regarding sobriety court, I have been putting in a lot of work, and I know that in March of 2025, there was a positive breathalyzer that I was unaware of for 2 weeks. I had met with Jamie, our caseworker at the time. She did not mention anything to me, and I did not know about it until I came to court, in which I would never, ever have a positive breathalyzer where I would not take the second test, or I wouldn't come in for a urine test or offer a blood test. So I was unable in any defense with that to do anything about. I was not drinking in March of 25. When I relapsed in September, I had like a massive amount of stuff going on. When I started sobriety court, I had a broken back from the surgery that I had. And I was on a cane, and I was doing physical therapy and injections. And then in June of 24, when I was in sobriety court, they found a brain tumor, which I started treatment for 3 months. And then when none of the medications were working, because I was having like severe allergic reactions to them and having to do like multiple EpiPens and different things, we rescanned, and the one got smaller, and then they found another one. And because of all of the dye that was going on, I ended up with kidney stones and kidney infections. And then during one of those treatments, they found that my bilirubin was really elevated because I have a liver disease anyways from when I was born. And then I started losing a ton of weight in January of 25 and went through multiple tests on my stomach, and they found a tumor on my liver. And then I was dealing with that for months. And then in August, I started having like a lot of pain where I couldn't swallow. And then in September, they found out that it was a tumor in my throat. And in March of 25, I had a falling out with my parents. And my mother is like my best friend. So in September, when I found out that I had to have surgery, I kind of had a nervous breakdown. And I truly believe that if I hadn't drank in September and graduated the program in October, I would be in a very different place right now. That would not be good. Because I told Judge Van Alst when I started that I would probably need the 24 months. And I know that with me going through what I was in September to December, and even now, if I would have graduated in October, I would be in a good place. And I did drive, and I am sorry. But I put in so much work. I see my therapist regularly, and I see a psychiatrist, and I do 5 breathalyzers a day, and I work 2 jobs. And I'm a single mom for 6 years, and I take really good care of my girls. And my therapist says that all the time, that she wishes you guys could see me with my girls. Because I do make good choices, and I understand that I make bad ones too, but I try really hard to be a good mom and to be a good person, and I take my sobriety seriously. I didn't join sobriety court for my driver's license. And I did relapse in September, and I have a lot of guilt over that. And I try really hard. And I just don't want it to be said that I don't do anything to better my life, because I try really hard. And I do a lot of it by myself. I would like you to consider that, because I don't get up and say a lot in sobriety court. It's very private. But we lost our house in October during sobriety court, and I didn't relapse. I found out my daughter has lupus, and I didn't relapse over that. I found out I just been through a lot, and I try really hard, and I chose every single moment of that not to relapse. In September I did, and I regret it. And me and Rosie had a conversation before that about me being almost 500 days sober, and I told her that that's not something that can be said to me or that I keep in front of me, because I'm not gonna be the one that comes up and says that life has gotten so much easier and I feel so much better being sober, because I don't. And it's something that I struggle with every day. My life has not gotten easier, but I keep trying. And I'm gonna struggle with it every day, but I keep trying. I'd just like you to know that.
Anything else? In case number 25-5088 ST, the court will keep this to fines and costs only. There is a $75 crime victims' rights fund fee, $50 state minimum fee. The court will waive the fines, costs, and attorney fees. I do that because I am aware, having worked with Ms. Nyman in the sobriety court program, the struggles that she does have and that she has talked about. And I also realize that she does still owe that court some fines and costs as well. So for those reasons, I'm just going to order what I need to in that file. 0 days jail with 0 days credit. In the, oops, sorry. Turning then to case number 24782 SD, which is the sobriety court violation case. The defendant, as we've said, this was not her first violation, and I do remember, I don't necessarily remember the first violation, driving the license was suspended. I do remember the second one, as far as Ms. Nyman not having an explanation or a reason why she tested positive, but she admitted to testing positive. And then in the third violation, the one in September, which has been mentioned a couple times today, she admits that she relapsed. And if I recall correctly, it may have had something to do with getting close to the graduation date. And, you know, had she not had that violation, she would have graduated by now. The court has, when it comes to sobriety court, only 24 months at its disposal. And while I didn't bring in the sobriety court paperwork today, if I recall correctly, her 24 months would end in April. The team had discussed what to do with Ms. Nyman, and honestly, no matter which way we looked at it, because for her first sanction, she had an essay. Her second sanction, we had increased counseling. Her third sanction was jail. There's a couple different ways that this could have gone, but either way that it went, it would not allow Ms. Nyman to be able to complete the program timely. When we get to the level that she's at with a fourth offense, it's a step downgrade or a phase downgrade. She would have to complete that and finish that phase and another phase back into phase 5. And there's just simply not enough time left in the program to do that. The court gets reluctant. I mean, we're a team for a reason, so the court gets reluctant to overstep the vote of the team. However, the court was willing to consider it had I been presented with some sort of evidence that that there truly was such a medical emergency that she had to go that day. But what I'm left with is somebody that drove themselves or attempted to drive themselves to either the ER or urgent care on the 12th of December. But yet, I understand getting scared off by the stop and law enforcement, but it's not until the 17th that she finally goes in for treatment. That's based on her testimony. That's not what I've been presented with, but that's what she says. So the court has to question how much of a medical emergency it truly was in order to cause the defendant to drive that day. And this is the second violation for driving without a license while in sobriety court. As such, the court is going to adopt the recommendation of the sobriety court team and terminate Ms. Nyman's participation in the sobriety court program. So Ms. Nyman, what the next step is that we'll have another hearing for probation to determine whether or not there is a probation violation in this case. Now, I want to be very clear, Hillary, and I mean this when I truly say it. You have made great strides through this program. I realize life is not easy. I understand that. And I understand that these seem like pretty minor things when we look at the grand picture of everything that you've been through, the strides that you've made, the number of testings you've done, the number of your counseling appointments. And remember where you were roughly 2 years ago when all this started and where you are now. I know you say, I don't live your life, so don't take it that way. I know you say that things haven't got easier, and maybe they haven't, but I can tell you from where you were then versus where you are now, you are a completely different person. And so don't let this setback set you back overall. You've been almost you've been almost 2 years sober. Don't forget that. All right. So the court will we'll draft that necessary paperwork. We'll get it scheduled for a probation violation. Can we do that today yet? Get it scheduled?
Yeah.
All right.
Mhm.
And then Hillary, you can go out to the front window where you checked in and get your next court date. Okay?